Welcome back to Justice is a Process. I'm your host, and today we're breaking down what might be the most critical testimony in the fake DTE workers' murder trial, the DNA expert. Sayera Ramirez took the stand on day 2, and the numbers she presented were absolutely staggering. We're talking about likelihood ratios in the octillions, 9.68 octillion to 1. That's not a number most people ever encounter outside of astronomy.
Right, and that's exactly what makes this testimony so important to unpack. Because when a jury hears octillion to 1, they hear certainty, they hear proof. But from a due process perspective, we need to ask, what does DNA evidence actually prove versus what does it appear to prove?
Let's start with what the prosecution established. Ramirez testified that Joshua Zuazo's DNA was found on a white balaclava mask with that 9.68 octillion to 1 likelihood ratio. Carlos Hernandez's DNA was found on a different mask and on an N95 mask recovered from his vehicle when he was arrested fleeing to Louisiana.
And here's where it gets devastating for Hernandez. That same N95 mask had Hussein Murray's DNA on the exterior, the murder victim's DNA on a mask found in the suspect's car. That's powerful evidence.
But it gets more complex. The white t-shirt, size 6XL, had Hussein Murray's blood on the exterior and Carlos Hernandez's DNA on the interior collar. Statistical analysis showed moderate support that Zuazo was not a contributor to that shirt. Meanwhile, very strong support that Hernandez wore it. So the prosecution's narrative is clear. Hernandez wore a shirt that got the victim's blood on it during the murder. But defense attorney Michael McCarthy's cross-examination exposed a critical limitation. DNA tells you who, but not when, how, or why.
Exactly. Could Hernandez have worn that shirt on October 11th? Sure. Could he have worn it weeks earlier and the blood got on it through secondary transfer, brushing against something bloody? Also possible. Could someone else have worn it? Theoretically, yes. The DNA can't tell you the story of how it got there.
And this is where the constitutional burden of proof becomes crucial. The state doesn't just need to prove DNA was found. They need to prove beyond a reasonable doubt that the DNA got there through criminal activity on the day of the murder.
Now let's talk about the most significant finding from a legal standpoint. The duct tape rolls found in the basement where Hussein Murray was killed. Both defendants' DNA was on both rolls. Very strong support that Zuazo contributed. Very strong support that Hernandez contributed.
That sounds damning, but here's the twist that defense attorneys will hammer in closing arguments. Neither defendant's DNA was found on the duct tape that actually bound Hussein Murray's hands, not on the zip ties that restrained him, not on the duct tape that bound Linda Murray. Think about that. 2 men allegedly spend 20 minutes binding 2 victims with duct tape and zip ties, yet they leave no detectable DNA on the restraints actually used on the victims, only on the unused rolls nearby?
Ramirez offered explanations. DNA can be removed, can degrade, testing decisions prioritized fingerprints over DNA for certain items, all scientifically valid. But from a reasonable doubt perspective, that's a significant gap.
Now, let's discuss McCarthy's cross-examination strategy for Zuazo because it was masterful. He systematically walked through every item where Zuazo was excluded or statistically unlikely to be a contributor. The N95 mask, Zuazo excluded, Hernandez included. The white t-shirt collar, moderate support, Zuazo is not a contributor.
The brown Timberland boots showed very strong support, 245 million to 1, that Zuazo was not a contributor to the exterior bloodstain. And when Ramirez tried to get DNA from the boot interiors, where you'd expect to find the wearer's DNA, she couldn't get usable profiles.
McCarthy's point, there's nothing definitively placing Zuazo's feet inside those boots. His entire defense is challenging identification, arguing that the state can't prove Zuazo was the second man. And the DNA evidence, with all its limitations, isn't giving the prosecution the slam dunk they need on that question.
Now, here's something that should concern anyone who cares about due process: the star MIX software issue. When Ramirez generates those octillion to 1 statistics, she's not personally calculating them. She inputs data into proprietary software that uses algorithms she can't fully explain. The software does biological modeling that incorporates factors a human analyst cannot manually assess. It's been validated by the FBI, it's used globally, it meets all standards. But the jury doesn't get to cross-examine an algorithm. They don't see inside the black box. They just get a number: 9.68 octillion to 1.
This creates a Sixth Amendment tension. The Confrontation Clause guarantees defendants the right to confront witnesses against them. But when the witness is essentially a computer program, how do you meaningfully exercise that right?
McCarthy also exposed something subtle but important about the statistical scale. Whether the likelihood ratio is 1 million to 1 or 9 octillion to 1, it falls into the same qualitative category: very strong support. The astronomical numbers sound more impressive, but they don't meaningfully change the strength of the evidence once you're already at very strong support levels.
Let's address what might be the most puzzling DNA finding. Hussein Murray's DNA was found inside the black Nike shoes, not just blood on the outside. His DNA inside where someone's feet would be. The prosecution wants the jury to infer this means the wearer stepped in Murray's blood and it got inside the shoes. But Ramirez was clear. She cannot tell when that DNA was deposited, how it got there, or through what mechanism. It could have been direct contact, secondary transfer, contamination during evidence collection. She simply doesn't know.
Paulette Lofton's cross-examination for Hernandez focused on different issues. She established that when Ramirez collects evidence, she wears gloves and masks to prevent contamination. Evidence goes in separate bags to prevent DNA transfer between items. Wet and dry evidence can't be packaged together.
And here's a significant investigative gap Lofton exposed. Deputy Copeland's body camera clearly showed officers discussing blood on the handrail at the top of the basement stairs. Multiple officers saw it. But the DNA analyst has no documentation of testing it, no photographs of it, no swabs collected. That matters because that blood could have been probative. Was it Murray's blood showing how the violence occurred? Was it one of the defendants' blood from a struggle? We'll never know because it wasn't collected or tested.
The nail clippings from Hussein Murray's left hand also tell an interesting story. You test nail clippings looking for foreign DNA, evidence of a struggle, defensive wounds, contact with an attacker. But the analysis excluded both defendants and showed very strong support that Linda Murray's DNA was present along with her husband's.
Neither defendant's DNA under the victim's fingernails. No evidence of a struggle that left the attacker's DNA on Murray's hands. Again, that's either explained by gloves and careful evidence handling, or it's reasonable doubt about the state's narrative.
So, where does this leave the case? The state has established that both defendants' biological material is on items connected to the crime. Hussein Murray's blood is on multiple items recovered from Hernandez's vehicle. The crime scene contains DNA from both victims and both defendants in various combinations.
But what remains uncertain is when that DNA was deposited, how the transfer occurred, what activities resulted in DNA being present or absent, and most critically, whether the DNA evidence proves criminal intent and malice. Because remember, under Michigan's felony murder statute, as modified by People v. Aaron, the state must prove malice, intent to kill, intent to do great bodily harm, or wanton and willful disregard that death would likely result. DNA on duct tape doesn't prove mental state. The state needs more than DNA. They need Linda Murray's testimony about blood on Zuazo's shirt. They need the medical examiner's testimony about brutal, sustained injuries. They need the ring camera footage. They need all the pieces to fit together.
DNA is powerful evidence, but it's not magic. It tells you who left biological material. It doesn't tell you why they're guilty of murder. That's the burden the state must meet.
One final constitutional point. Despite DNA evidence with octillion to 1 statistical support, Carlos Hernandez and Joshua Zuazo remain presumed innocent. The DNA proves biological presence, not criminal guilt. The jury must still evaluate whether the totality of evidence proves guilt beyond a reasonable doubt. Justice is a process, and understanding how DNA evidence fits within that process is crucial to evaluating whether the system is working as designed. We'll continue following this trial as it unfolds.